Great, so we're going to begin. Thank you all for selecting this track of the program this afternoon. This panel is titled Motion to Dismiss, Multi-Stakeholder Norms and the Roles of Court in Internet Policy. I'm Andrew Bridges from Fenwick and West in Mountain View, California. Our speakers today on the panel are Anupam Chander, my far right, who's at the Georgetown University Law Center. By video from Paris, I presume, Bertrand de la Chapelle, the Executive Director of the Internet and Jurisdiction Policy Network, Llansó, the Director of the Free Expression Project at the Center for Democracy and Technology, Stephen LaPorte, to my immediate right, Legal Director of the Wikimedia Foundation, Sternburg, the far left, the Senior Policy Counsel at the Computer and Communications Industry Association. Did I get the order right? Okay. And to my immediate left, Suzanne Woolf, an independent consultant. The overarching agenda for today has about 3 topics. We have a number of scenarios to discuss. Some of the speakers have selected a particular scenario they're interested in. They will focus on them. But the 3 main issues that we're addressing today are as follows. First, what effects do national court decisions have on the internet and on those who use it? Second is, what are possible solutions to conflicting internet-related court judgments? And third, how, if at all, should multi-stakeholder outputs or policies inform judicial decisions? So I'm going to ask each of the panelists to introduce themselves, say a little bit about their interest and perspective in this arena, and to give some opening remarks of 2 minutes each. And why don't we start with Anupam?
So, thank you, Andrew. So I want to begin with one of the scenarios that has been drafted for this. So the idea is, picture yourself sitting in 2025, and in 2025, we're looking back at a European ruling that says that in applying the GDPR, it should be applied to an American company, even one with a small number of European users. And so this leads then, over the next 7 years, to companies all over the world essentially complying with GDPR, sort of using that as their basis for how they manage their data. And so that means as well that this has kind of, some less than obvious consequences. ICANN has a who is function that allows you to figure out who registered a domain name, or at least it has a process by which, even if the person hasn't revealed himself or herself to the public, that the registrar knows who has registered the domain name. And so the GDPR might, on the other hand, make that process less visible, and the ability of ICANN or its registries to gather that data much more difficult. And this is the scenario poses, despite efforts at ICANN to come up with kind of global multi-stakeholder norms around access to who is data. Okay, so this is.
Let me cut you short a little bit, because we're going to come and drill into the scenario.
Got it. Good.
Just give us just a minute on sort of your research and your main interests.
Good. Okay. So my area is to look at kind of the global regulation of technology. Technology is global. It can't be bounded within nation states, as the IGF demonstrates. And so that's my general area.
Okay. Shall we go to Bertrand next, and then Emma? Bertrand?
Yep. Do you hear me?
Your interests, and then we'll come back and drill into scenarios later.
All right. Hi, everybody. Thank you for allowing me to be in there. So I'm the Executive Director of the Secretariat of the Internet and Jurisdiction Policy Network, which is a multi-stakeholder organization founded in 2012, based in Paris, that facilitates a dialogue internationally between the different stakeholders on the tension between the cross-border internet and the patchwork of national jurisdictions. As an introduction to this panel, we have 3 programs that highlight this tension that we might be able to touch upon in the course of my comments. One is on cross-border access to digital evidence in criminal investigations, initiatives in the US regarding the Cloud Act, in Europe regarding the production orders proposed by the European Commission and the Budapest Convention Protocol. The second topic is everything that is related to content restrictions, when the content is illegal on an international platform. And the third program is about domains and jurisdiction, and when it is appropriate or not to take down a domain name because of the activity that is conducted on the site underneath. Just one comment as an introduction. In the context of this panel, it's interesting to discuss elements that are related to extraterritoriality in particular, and in different dimensions regarding when the digital environment, and particularly the notion of committee, the role of courts in weighing the different interests that might be involved in the case and the different nexus of connection to the case on a territorial basis, and also touch upon, if the discussion comes to that, on the role of multi-stakeholder norm setting or processes that are developed at the moment mostly in the field of governance of the internet. It's ICANN, it can be technical norms in the ITF or elsewhere, and much less at the moment in the context of governance on the internet regarding the usage of the internet. And that's what we are focusing on mainly.
Thank you, Bertrand. Next, Emma, please.
Hi, my name is Emma Llansó. I'm the director of the Free Expression Project at the Center for Democracy and Technology, which is a nonprofit public interest organization with offices here in DC and also in Brussels. My role as director of the Free Expression Project involves working on law and policy issues across a number of different kind of ways that our access to information and ability to find platforms for our speech online are affected. So that includes everything from fundamental rights protections, looking at things like First Amendment and Article 19 of the European Convention on Human Rights, and what that does to constrain government power to censor or suppress speech. The role of intermediary liability limitations and the kind of the laws that shape whether and how intermediaries, be they content hosts, access providers, search engines, domain name system, what liability do they face for enabling access to user speech. We also do a lot of work on content moderation and the choices that private companies, content hosts make about what they do and don't host and how they inform their users of it and what kinds of options for appeal they provide, if any. And I think this question about the role of the courts is really interesting because in a lot of the work that we do, we kind of tend to, incoming call, we tend to think of the courts in a lot of ways as a measure of last resort in fights about national domestic policy, right? If a legislature is considering a law that we think is very overbroad or would constrain speech in a really problematic way, you fight it out in the legislature, but you also look to the courts as a way to bring that kind of fundamental rights protection into play. But courts can also obviously really throw a wrench in things as far as the internet is concerned when they look at kind of application of national law to what is a globally interconnected network. So I'm also very interested in looking into some of the issues that Bertrand mentioned around, on the one hand, the court's interest in finding effective remedies for the issues that come before them, whether it's an infringement of copyrights or violation of privacy rights or reputation rights in defamation cases. And how they balance that with the need for proportional measures, and to ensure that remedies provided by courts don't go so far in protecting one set of rights that they run roughshod over another.
Thank you, Emma. Stephen.
So hi, I'm Stephen LaPorte, legal director for the Wikimedia Foundation. You've probably heard of Wikipedia. That is the website that the Wikimedia Foundation hosts. We are a nonprofit located in San Francisco, California that runs a website primarily based out of the United States, but developed by people around the world. Wikipedia has over 40 million articles and is available in 290 languages, depending on what you count as a language. So you can sort of see how there's a potential question of international liability, or basically you have to figure out what law applies to this large project that's being built by people in a decentralized fashion around the world. Depending on how you look at it, Wikipedia might be the easiest place to get information removed. It's open for anyone to edit, or perhaps the most difficult place to get things removed, because you have to go through a community of editors who are very passionate about free expression, which means that when we receive a takedown notice, we have to process it not only considering what the law requires us to do, but also what our community wants and what our own editorial standards and values set. And that's really pitted us in a few awkward conflicts, and I think we'll talk about a few of those things that impact Wikipedia's work generally and some of the hypotheticals that will come up later. But I would categorize them in two areas. There are problems of sort of a rock and a hard place, where you're caught being asked in two different jurisdictions to do two different things that you can't do at the same time. The second category is one that I call the lowest common denominator effect, where essentially the least free country in the world gets to dictate the standards for everyone else, because you comply with the law that is the most restrictive. So there's this kind of race to the bottom. And I think there's a really interesting component of both of these, where you have pieces of law that are being applied in a way that doesn't reflect the entire context of the legal regime that those pieces of law are built to be part of, which really affects the proportionality or some of the larger policy goals that law aims to achieve. And I think we'll illustrate some of these in some of the examples later.
Great, thank you. Ali?
Sternburg, Senior Policy Counsel at CCIA, the Computer and Communications Industry Association. We're a nonprofit trade association of internet technology companies with offices in Washington, D.C. and in Brussels. And we work on a variety of areas of law and public policy that impact the internet and technology industry. I focus primarily on copyright and intermediary liability rules. And two CCIA materials that I wanted to talk about a bit today later in my remarks are, one is a paper that we, an update to a paper that we released today entitled Modernizing Liability Rules to Promote Digital Trade. And the other one are comments that we filed with the PTO related to the draft Hague Convention on recognizing and enforcing foreign judgments. And in both these materials, we talk a little bit about the importance of maintaining and exporting liability rules that provide certainty to internet platforms and thereby encouraging speech and innovation online. We talk a little bit about IP and non-IP liability rules that... Do you mind that? I don't have, yeah.
Well, they can't hear you. Bertrand can't hear you. Nobody can hear you.
Here.
That's okay now. I hear better. No, that's better.
Sorry, thank you very much.
Thank you.
Okay, thank you. And some of the case studies that I'll talk about a bit more later are the Ecostec case in Canada and a case about the right to be forgotten in France. And I look forward to kind of talking a little bit more about how courts impact public policy and impact innovation and speech in the internet space and for the users of them.
Thank you, Ali. Suzanne.
Thank you. I'm Suzanne Woolf, and I'm here primarily as a technologist with a lot of experience in the multi-stakeholder structures that drive internet technology, such as protocols and standards. I've been very active in the IETF, also in the ICANN community. One thing about that, of course, is that engineers tend not to think about what we do as multi-stakeholder or governance or any of those things. But the process of figuring out how to accommodate the different commercial and social interests in open standards and open source software that everyone can use is a big part of how we got multi-stakeholder internet governance in the first place. And I also tend to think of that kind of work as the primary job we have now is making sure that we continue to enable multi-stakeholder dialogue in areas that are outside of the technology, strictly speaking, but that we need to be able to enable and support. I spent my career on the internet and building internet infrastructure. I started in the mid-1990s. But I've never really been a techno-utopian. It's always seemed to me that the internet would turn out to be interesting and new and endlessly shiny, but also no better and no worse than any other human, social, and technical construct. That's why when I was studying technology, I also studied history and economics. Today's topic is interesting to me, even though I wasn't quite sure where to start. That struck me as kind of the interesting part. I'll talk some more later about a couple of the organizing principles of the technical architecture of the internet that I wish courts understood better. There's some principles that have been developed by a lot of people in lengthy process over, at this point, a long period of time that I hate seeing, and I hate seeing that accumulated experience lost because we don't know how to share it. But by way of introduction, I'll say that I do think technologists need to show up more and try to get their viewpoint into legislative and court proceedings more, because it's much better than it once was, but there's still a lot of collateral damage going on to the openness and usefulness of the internet that goes way beyond resolving contending interests. To some degree, fragmentation is a fact of life. The single unified internet never really existed. There were AUPs on university networks in the 1980s. But at the same time, I think we're giving up connectivity and permissionless innovation and their benefits a little bit faster than maybe we must or than we should. So I look forward to the discussion.
Great, thank you. So now we're going to move into part of the program to focus on the effect of national court decisions on the internet and its users. We're going to start with Anupam giving a 3-minute overview on conflicts of laws. Then Emma, Stephen, and back to Anupam will be responding to some of the scenarios that we came up with for this panel. So Anupam, why don't you start us off on conflict of laws, please? I can condense that entire subject into 3 minutes.
So the fact is, of course, that interjurisdictional conflict has long existed, and lawyers have had to deal with things that spill across borders for centuries. And so this isn't a unique thing to happen, but the intensity and the ubiquity of such conflict has never been as, this is unique and unprecedented today, right? So the internet makes everything global and everything also kind of not anywhere in particular. So it's everywhere and nowhere at the same time. And so it means that when any court legislates, when any court imposes a directive on any party that reshapes the local internet, that causes ripples on the global internet. And so, this means that there's always this kind of jurisdictional concerns that happen. Now, conflict of laws has kind of dealt with these questions by getting courts to try to retreat sometimes, to not insist necessarily on choosing the local law as the law that will govern that particular conflict. And so a court in a particular jurisdiction might choose to not apply its law, might choose to apply the law of a foreign jurisdiction in certain cases. Now, that's unusual, certainly. The typical thing for a court to do is to assume that its law applies. That is, the law of its jurisdiction applies. The lex forum will be the one that controls. So that tends to be the rule. But I think in the internet space, and I think Bertrand already mentioned the term comity, which, as my law school professor used to say, is not funny. Comity is the idea that courts might approach an issue that's international with some humility, might say essentially, we're not going to insist on the full measure of our own law because of the international ripples that this intervention has. And so I think that is a critical intervention from the conflict of laws approach, where judges really need to step back and think, does it make sense to apply our law to this particular fact pattern? That is, are our concerns so significant that they override the global concerns with our intervention?
Thank you. So now we'll go to Emma on a copyright scenario. And that is, by the way, we're trying to avoid talking about actual cases that have just happened that are pretty controversial. We're trying to look ahead and get some guidance and some thinking about some hypotheticals that may be closer or farther, depending on the circumstance, from recent history. But for Emma, it's the hypothetical scenario is that an American court orders a file sharing site based in China to prevent copyrighted content from being seen or downloaded by US residents without explicit permission of the copyright owner, even though sharing of some of that same content was explicitly permitted in China. The US court then orders cloud providers and ISPs to prevent any US access to the Chinese website, despite experience showing that DNS blocking causes collateral technical problems. The US court order is followed by many providers, causing a dramatic decline in traffic on the Chinese website. As a result, the site removes content to comply with US law, even though that content is legal in China and in several other countries. Emma, take it away.
Great. And my phone just locked, so I can't time myself. Have fun. Let me know if I'm going way over time. But I wanted to point out, I think this is a really interesting scenario, and rather than drill into the nitty-gritty of comparative copyright law, I thought I'd point out a couple of the kind of the key dynamics that this scenario puts before us so that we can talk about them in some more detail. So obviously, first off, there is this conflict of laws problem, right, where the copyright law in the US and the copyright law in China come to different conclusions on the sharing of the same information. There's also the basic jurisdiction question. Does the US court have jurisdiction over this Chinese site? Under traditional kind of personal jurisdiction analysis, the likely answer would be no, unless the Chinese website had personnel or servers here in the US. So it's also this question of, what is the court trying to do when it serves an order on somebody who is outside of its jurisdiction? Does it have really any anticipation that that will have any effect? But I think there's also some other, and those two dynamics of questions about jurisdiction and conflict of laws, we've already talked about a little bit. Those will probably come up in all of the cases that we look at. But I thought this scenario also provided some interesting other issues for us to think about. One being, it talks about the US court then serving orders on US infrastructure providers. And the court will certainly have jurisdiction, a US court over US-based infrastructure providers, access providers, parts of the cloud hosting here in the US. But it's also not clear under the scenario, were those parties ever part of this case? Or is the court serving an injunction on non-parties to the case? And why this is really important to think about is, if a court is serving an order on an entity that could have technical control over how information flows, but wasn't part of the case, we've missed an opportunity for the court to fully grapple with the consequences of that order and to say, to really think through, is ordering essentially network level filtering the right remedy here? What are the interests and incentives at stake? Because in general, a lot of us think, certainly in the free expression advocacy community, network level filtering is a bad remedy. It tends to be, in addition to the technical issues that the scenario mentions, some of you in the room may remember the SOPA PIPA fights and what the DNS blocking orders in that legislation would do to DNSSEC, security extensions for domain name system. There's also just very fundamental free expression issues. An order to block an entire domain name typically overbroad because there may be both infringing and non-infringing content on that site. It also serves as a sort of prior restraint on speech. It not only blocks the infringing content at that site at that time, but anything else that might be posted on that website in the future. So there's some core kind of First Amendment issues here, and the order the judge serves on the US infrastructure provider may well be unconstitutional, but if there's no opportunity in the proceeding of the case for that to play out, then the court doesn't have, if there's no one who's part of the case who will make those arguments, then the court doesn't have a chance to really consider them. And then I think that it's the last sentence of the scenario where we hear, a lot of the US infrastructure providers complied, led to the Chinese site complying with the spirit of the court order. They take the content down even though it had not violated the law in their country. And this is, unfortunately, a very good example of how courts can try to exert extraterritorial effect of their nation's laws outside of their jurisdiction, even without any actual power to compel action by websites who are outside. We love the internet for how interconnected it is. It has a lot of resilience against censorship because of that, but the downside of the interconnectedness is that if you find choke points, if you find leverage points, either technically or just kind of in practical effect of impeding substantial amounts of traffic to a site, you can still have a sort of coercive effect over websites that are out of your jurisdiction. Big question for me here in thinking about all of this is who is accountable for these effects, especially when it's this sort of court orders infrastructure providers in one country to prevent access to a website in another country. Where does the person legitimately trying to access, maybe from a third country, trying to access content on that foreign hosted site, who do they kind of bring their fundamental rights claims to? And how do we get into, at what phase of all of this discussion do we get courts to look at the fact that the effect of their order is chilling on a lot of rights that were maybe not part of the original discussion in the case? And I also think it points to a trend that we are very concerned about seeing, is that if if a situation with especially content being hosted online can't be resolved at the application layer, if it can't be resolved by the website that is hosting that content because they're either not in your jurisdiction or they're not cooperative, or whatever it might be, the incentive for either legislatures or courts to kind of push further down the stack and say, if we can't get the website to take it down, we'll make the networks block it, we'll make the domain name system not resolve requests for that domain, and that gets the censorship activity deeper into the network, and I think is even more pernicious than kind of putting the application layer providers at risk of liability for the content they're hosting.
Thank you. Stephen, on right to be forgotten. The scenario is that the European Court of Justice orders Google to suppress, on a global scale, search results that were de-indexed pursuant to a claim under the right to be forgotten. One case involves a German currency trader requesting delisting of his earlier convictions for insider trading. Another involves an Italian politician who sought delisting of negative media coverage of an earlier corruption investigation. This immediately creates a clash between courts and norms in the EU and elsewhere. In the UK, by now under the hypothetical, no longer part of the EU, norms in courts regard the right to know just as highly as the EU's right to be forgotten. In the US, laws in courts have held that employers can be liable if they fail to use reasonable diligence to discover past criminal activity of the people they hire. Take that away.
Yeah. So, I wish that that hypothetical was maybe a little more hypothetical and a little less close to home. So, Wikimedia has been voicing concerns about the implementation of the right to be forgotten since 2014. It's been an ongoing debate around not just what this right is and whether or not the right should exist, but how the right is implemented in a way that effectively achieves its goals. And I think from Wikimedia's perspective, we see this as a fundamental issue of people's right to access information. We think a lot about free expression as the right to speak, but there is a corresponding right to receive information as well. And that right to receive information, I think, is only increasingly more valuable as we move to an information age, a connected society online. People talk about in the age of the internet that speech is getting cheaper, it's easier to put information out there, but attention remains very scarce. The ability to sort through lots and lots of material is something you need technical tools, like a search engine that Google provides, to be able to do. And I think a lot of people, people who want to suppress information, are recognizing that placing limits on speech can be difficult, and placing limits on attention by drowning it out in lots of material or going after the ways people receive information is a much more effective way to make information less available. So at its core, there is an attack on this right to receive information. But not to be just too one-sided about the discussion. There is a corresponding right that individuals have in Europe to remove information about themselves, and there's a balance between these two. And I think the hypothetical really spells that out very well. So I think it's useful to look at the specific examples that were brought up in the hypothetical. There is a German individual with a financial crime in their background. There is an Italian politician with some corruption in their background. Now, in these hypothetical cases, you can see why the individual might want that information off the public record. But it's also equally important to consider why the people that are not those individuals want that information to be on the public record. When you're electing a politician, you want to know what their past scandals are. When you're hiring someone, you want to know if they've been convicted of fraud. These are things that the public has interest in. And the setup of the right to be forgotten and the setup of a global application of that rule really imbalances that discussion, because you have a lot of the questions that were raised previously around the effects of non-parties to the case. And similarly, there's a number of really important underlying questions that may not even be asked in this proceeding. So I would like to know, is the speech itself legal? Are we allowed to say these things in Germany or Italy? The hypothetical doesn't tell me if the speech was legal or illegal, but I'm assuming it is legal, and that's why they're going after removing it from Google rather than getting it taken down from the place where it's first being published. And then the second question I have is, how do those other interests get represented in the proceeding? Where is the due process, not just for the individuals, but for the other people with rights that are being affected by this? And then finally, if this is being applied globally, how is it being applied in a way that reflects the balances of laws in multiple jurisdictions? So in Wikipedia's case, if information does not have a proper citation to it, it will be removed from the encyclopedia. It will get taken down. It's something that Wikipedia handles on a daily, probably minute-by-minute basis. And if the right to be forgotten is implemented as it is today, and it will likely continue to be, I guess, under this hypothetical, there's a real lack of transparency around the actual subject of the controversy. So a notice is being sent to a search engine that says, there's a corruption scandal in my background, please take me out of the Google search results. Now, if Google is feeling good-hearted and particularly transparent at the moment, maybe they will tell the people who are searching for that individual that something in your search results is missing. And maybe they will tell the people who actually have that information in the first place that you have been removed from the search results. Let's just say, hypothetically, that's a Wikipedia article. They often do not tell that individual, the Wikipedia administrator, why the information was removed. They just say, your article on such and such Italian politician is now gone from a search result, which leaves us guessing on why this information was removed. So going back to the hypothetical, if we were to assume that individual had a good case to get information removed, and they should justly have this information not on the public record, by going through a search engine, they are not enabling us at Wikimedia to take that information down until they contact us. So this indirect way, this way that doesn't consider the sort of due process of all the parties involved, that applies it disproportionately, not only affects the individuals who want to get access to that information, but also interferes with the ability of the right to be forgotten to actually serve the people it's intended to protect. And all of these are part of a really strong ongoing debate. I don't think that any of this is going to settle, the right to access information is more important than someone's privacy. But ultimately, these are balancing acts that need to be done in consideration of the local context. So Wikipedia is written on a language-by-language basis. If you search that Italian politician on Wikipedia, you might find something different than when you read about them on English or on German, because different communities might have chosen to describe that individual differently. And we get this local nuance because the law applies locally, and applying it broadly loses out on all of that nuance.
Thank you. Anupam, you're doing GDPR, right? Yes. So let's say that a European court confirms that the GDPR monetary fines could be assessed against US companies that serve even a small number of European residents, even when they are on American soil. That ruling prompted most US businesses to apply GDPR regulatory restrictions to all their users in order to avoid ruinous fines. Also, ICANN's registries and registrars further restrict what they can reveal about domain registrants, despite a year-long effort to generate a new consensus policy for access to non-public who-is data. Take it away.
So this is a great scenario. So it posits that the GDPR has gone global, that companies across the world, including the United States, are now govern themselves through it for fear of sanction in Europe. Now, many people will cheer that, right? That will be kind of, if you took a poll on my Twitter page, I think you'd say, probably you'd get most people saying that's a great thing, and that yes, the GDPR is better law than the United States has. I think there's some reason to be concerned about that. Now, I don't know about this room, but I think there's some reason to be concerned about that. And the concern is that if it were better law, then it should be really properly go through whatever processes we have in this country to enact it as law. And this is the complication in this area. Once we have one jurisdiction that kind of is able to, because of its large size, insist upon its way across the world, that means that other jurisdictions will not have the ability to enact their own laws that might differ. Now, this does mean that, and this is complicated. That means that if there are different laws across the world, that means that some people would like the same law across the world for the internet. So the internet should be governed with the exact same rules across the world. I think that's unlikely for the immediate future, at least around questions of content moderation or privacy. I would like to see more kind of global agreements, multi-stakeholder processes, international treaties, et cetera, that achieve these things, but I think that's a little bit, that's a process that we need to be working for. So in other words, just to recap, I think that a lot of people would think that the application of the GDPR globally is a good thing. My preference would be, if that you think that's the case, then instead of this kind of de facto GDPR being imposed on the world for fear of fines, it should be imposed through democratic processes in local jurisdictions. I think that would be a much more healthy democratic process than relying upon Brussels to have our best interest at heart. Okay.
Thank you. So now we're going to turn to discussions about different policy approaches to the question or problem of conflicting national court judgments. And we're going to start with Ali for 5 minutes on this topic.
Thank you. Use the mic now. Sorry about that before. So if folks weren't able to hear me because I wasn't mic'd, just want to reiterate that there are two CCI materials I wanted to talk a little bit about today. One is our new update to our paper on modernizing liability rules to promote global digital trade. And the other were some comments that we filed last year before the PTO on the Draft Hague Convention on enforcing international judgments. So first of all, our modernizing liability rules paper talks a little bit about the impact of certain types of court decisions on industry and on internet companies and their users. And we heard a little bit about some of the types of cases and opinions. I know they're hypotheticals, but there are
a lot of that is real and has a real impact. And so, for example, there are a few different types of court judgments that can have this type of impact. Sometimes there are orders where a court will order global relief, not just in the country where the court is, and other times there will be attempts to get a judgment in one country and then kind of export it through international enforcement. And so some of the cases that we talk about in our paper as case studies include a Canadian case where the court there was an injunction against Google, who was a non-party to the lawsuit, and so they weren't the defendant. They were a non-party, and often when there's a non-party, there's a lack of due process. They're not always given notice and an opportunity to be heard. So there's definitely a challenge in procedural law, but also substantive law is often different between different countries. For example, the US has certain defenses in our copyright and trademark law that might be more protective of free speech than in other countries. And so there's definitely a lot, and there are other substantive law differences, differences in copyright term, differences in the US has a fair use doctrine in copyright and trademark law. A lot of other countries do not. So there are certainly some tensions between different jurisdictions that can really have an impact if there's an attempt to try to enforce other type countries' laws in a country where it doesn't match up and it's not as protective of free speech and of innovation there. So one policy change that could help that is to provide these important online intermediary protections in the IP context, copyright and trademark, and also in non-IP contexts around speech, such as the Section 230 protections that we have in US law. Other responses to this can be discouraging courts from enforcing these types of extraterritorial judgments against online intermediaries. And another thing about this is there's been research showing that it's not just kind of a hypothetical risk to innovation. There are two studies that were done a few years ago around the impact of copyright decisions on investment in cloud computing. And one of them looked at the US copyright decision in the Cablevision case, which dealt with the lawfulness of DVR recordings, basically, and time shifting. And after that decision, the research found an increase in investment in US cloud computing firms. And then the next year they did a study on decisions that took place in France and Germany that did not find this kind of activity lawful and found a corresponding decrease in investment. So these decisions can really have an impact on industry and on entering markets, leaving markets, expanding products. And so there really is a serious impact that court decisions can have on US industry and industry in EU and around the world.
Great, thank you, Arlie. Bertrand, can we hear from you on the policy approaches to conflicting national court judgments? We're not hearing. Now we have you. Okay, so five minutes, please, thanks.
So these are extremely diverse topics. I just want to take the opportunity to share a few comments that touch upon some of the things that have been said. The first thing is, Anupam was right to mention the fact that actually the main problem is that transnational is the new normal now. What used to be exception is now the bread and butter of all the interactions that we have using technology. The second element is Suzanne mentioned something that is very important. And it's not only a matter of educating the courts, or the right in that regard, it's the question of the understanding of the technical architecture, and particularly one topic that is not raised enough, which is the importance of the neutrality of the technical layer, and particularly the use of the identifiers. One of the programs that we have is about the domain name system. And as I said, whether it is appropriate or not to have a domain name that is taken down, which has a global effect because of an activity that might be illegal in one country, which if stated like this, shouldn't be the case. And so fundamentally, this neutrality of the layer of identifiers is something that is probably not sufficiently in the minds of the different actors. There's another word I want to pick, which is the word balancing. because we are very often using this word, and within Internet and Jurisdiction Policy Network, we tend to advocate for the use of reconciling. Because in many cases, it is not about choosing one principle versus another in a sort of zero-sum game. There are cases where it is possible to reconcile those things. And there's been long discussions, for instance, on the question of anonymity in another space, and how much it has a dimension of protecting security and privacy at the same time as raising some concerns of security at the same time. So reconciliation between different competing objectives is a core element. And in most of the topics that we're talking about, the main objective is to reconcile three things, and no particular order between them. It's reconciling the fight against abuses, because there are abuses and they need to be addressed, the protection and strengthening of human rights, and making sure that in doing so, we also enable a thriving digital economy. And in many cases, it is possible to accommodate those three things together, but it is important to keep in mind that this is not necessarily to choose, balance one versus the other, but to reconcile them. And in that regard, I want to highlight that this notion of coexistence and the notion of reconciling is something that is connected to the word community that was mentioned. And actually the responsibility of courts and of a certain number of other actors is to go beyond the traditional application of conflict of laws rules, which basically says it's either law A or law B, but rather to say there are situations where you can have the combination and the coexistence of law A and law B. If you have a content that is illegal in one particular country with a country that has a sufficient guarantee in terms of freedom of expression and so on, but it is legal elsewhere, you can have modalities of filtering it through the platform, GeoIP or other, in that particular country, while making it accessible still everywhere else. And this actually combines the respect of the two types of laws. So there are technical solutions that have to be thought of when we want to reconcile those things. The other point I want to make was the comment that I found very interesting regarding the tension in Wikipedia and Wikimedia between the decisions by the community itself and the different laws. And I think there is a discussion that has to take place to maybe within the community of Wikipedia itself to contribute to the discussion of how much and under which conditions should national laws be respected fully when there is an issue of restriction of speech. Should it be filtered, should the content be filtered in a particular country just because the law there stays so? Or are there additional criteria that would allow to maintain it online even if there was a decision locally, because there is a general agreement that the laws is too restrictive in that particular case. And finally, one element that is very interesting, there were different comments regarding harmonization. And I think there is a general agreement that harmonization for speech, for privacy, and etc., at the global level is neither achievable nor probably desirable for many reasons that all of you have full understanding. The key question and the key concept that we are pushing within Internet and Jurisdiction is the notion of legal interoperability and the focus on due process mechanisms for anything that happens across borders. And so the element that is related directly to the discussion we have today on the role of courts, what is interesting is that things are evolving so fast that everybody is now looking at one single court decision somewhere in the world to identify what is emerging as a sort of a global jurisprudence. Like we are trying to find what are the core elements to define those principles. The mention has been made of acoustic. Everybody is looking and waiting for the decision by the European Court of Justice on the right to be de-indexed. There was a big attention to the Microsoft case in the context of cross-border access to data for criminal investigations. And you can cite a few of them. We are more and more looking at courts for setting some norms that will have a ripple effect. And it is important that those courts are conscious of the ripple effect that they are making. And the final element is that the companies themselves have an extremely strong role, voluntarily or involuntarily, to develop norms that are actually of a global implementation. And the hypothetical that was mentioned regarding the GDPR is a perfect example. But I would like to highlight that this is also the case for some elements of speech. And as a note to make you smile, I want to read you just 2 lines of what is in the terms of service of one company that I will not name, that says that you should not upload, download, post, email, transmit, store, or otherwise make available any content that is unlawful, harassing, threatening, harmful, tortious, defamatory, libelous, abusive, violent, obscene, vulgar, invasive on another's privacy, hateful, racially or ethnically offensive, or otherwise objectionable. So we can have a long discussion on what is the application of the different laws. We now have to deal seriously, and this is a responsibility that the companies are perfectly conscious that they have, of distributing the responsibilities between what is in the terms of service, which would have, by the way, in this case, a global application, and the national laws when they are appropriate or not. Basically, what is at stake is what is the digital society that we want to build together.
Thank you, Bertrand. I'm going to tell the panel that we have some very good news. I've discovered a mathematical error in our agenda, which means we actually have some extra time on this section. I wanted to throw a couple things out and see if I can bait some hooks for people to take. Number one, how many of these issues are truly international issues versus accumulated or aggregated national issues? So for example, the problem of people being subject to court judgments who are not present before the court seems to me to be pervasive everywhere. Courts decide cases between litigants, and there's no public interest attorney often appearing as counsel for the public defense to argue a public position. That the idea is that's what legislatures are supposed to do in their enactments. How much are we going to blame courts for this when most courts are implementing what they perceive to be national law, often law from the legislatures? And so are we blaming courts for the lack of legislative harmony? And we like to talk about courts giving comity as a humility principle. I have yet to know of any legislature that adopts humility as its own precept. And then what do we do with the fact that really there is only one layer of entity that truly has transnational global jurisdiction? And those are global enterprises who set their rules often at a global basis, reacting to different pressures and different influences in the various jurisdictions where they feel vulnerable because they've got boots on the ground or money in a bank account that can be seized or thrown into jail. So if anybody wants to grab at any of those, I would be grateful.
So let me just pick up on the humility point. The US Supreme Court has, for the last 2 decades, reinvigorated a humility principle of US prescriptive legislation, prescriptive jurisdiction, which is the presumption against extraterritoriality. That is, whenever a US court looks at a law passed by the federal government, it says that law only applies within the United States, unless the law explicitly declares otherwise. Okay? So in other words, Congress, whenever it acts, is confining itself to the United States unless that statute explicitly says it's acting abroad. All right? So in some sense then, Congress is being humble in that narrow sense, which is hard to imagine, by failing to include this law applies outside the United States.
Okay. Anyone else?
Yeah, can I chime in if it's possible, whenever it's time?
Yes, please. Go ahead, Bertrand.
Yeah, I'm very glad that Anupam mentioned that because the question of extraterritoriality is a very important one. And I don't know if the right ability, but someone who is, that many of you may know, was Dan Svantesson, has pushed forward the notion of the combination of interests when determining the jurisdiction of a court or the jurisdiction, the application of a judgment, or even the development of a national law. And I would recommend for those of you who are interested with the notion of comity and all those questions of extraterritoriality, remarkable chapters in the book by Stephen Breyer, the Supreme Court Justice, that is The Court and the World, where he has long chapters and paragraphs about this notion and the difficulty of measuring it. The point I want to make is that this is at the core of the exercise of sovereignty in the digital age. We are accustomed to an architecture where basically sovereignty is primarily and almost exclusively territorial, an international architecture that is based on the separation of sovereignties and a principle, let's be honest, of non-cooperation. And we're confronted with situations where, because of the transnational nature of most of the problems that we're dealing with, there is a need for legislators and courts to think about taking into account all the different impacts and all the different interests that are at stake. And I want to finish by saying extraterritoriality in that regard was deemed inappropriate in the past. More and more, it is likely that it will become a tool. It is just that it has to be exercised with precaution and with caution, so as not to create disproportionate transborder impacts when enacting a law or making a court decision. So extraterritoriality is not as objectionable as it was before. It will become a tool that will be taken into account. It just has to be with caution.
Thank you. We have another half minute or so before we... Oh, okay. We'll go ahead. Go, Emma, then Steve.
Just very quickly, it's a great point that you raise about the kind of the transnational effect of internet companies' content policies and the kind of the standards that they articulate that they do try and intend to have apply to their users kind of all around the world in an equivalent way. And that has led to a lot of folks, including I think most recently the UN Special Rapporteur on Freedom of Expression, David Kaye, arguing that probably the globe-spanning content hosts that we have on the internet today could look to international human rights law as a set of internationally legitimate norms for speech and for handling issues of hate speech, defamation, and what have you, because they are operating at this international scale. And whatever you may think of it, international human rights law is the kind of the most globally accepted, legitimate kind of effort that we as humans have for deciding difficult content issues. So that's definitely part of the debate right now. I don't know if any of the big platforms have taken him up on that, but that's certainly part of the conversation.
Thank you, Emma. Stephen.
And I guess in completely reverse chronological order, I will give you an unsatisfactory response to your very first question about the public interest representation and all of this. I think fundamentally, at least from my perspective, it is an issue of democratic principles. There are courts in France that are looking to apply French law in a way that is not something that I, as an American citizen, have a chance to vote on. And that means that the laws reflect not necessarily just the decision that's going on in the court, but the decision of a legislature that is not listening to sort of the global impact that their decisions have. So whether or not the court is the right place to be having that debate is a really good question, I think, and a question the court will probably ask itself. But at the same time, it might be the first place we have to have that debate because we do not have the international bodies to handle it otherwise.
Thank you. So now we'll move on to the next part, which is to discuss the relationship of the multi-stakeholder outputs to judicial decisions And first we'll hear from Suzanne. I have a question for you briefly, Suzanne. Do you want me to set up the particular scenario here, or do you want to comment generally?
If you want to set up the
I'll
scenario.
set up the scenario, okay.
That will
Sure.
be a place to stand.
Great.
Thanks.
So this scenario posits that in 2023, renewed international terrorism and cross-border cyber attacks leads to increased electronic surveillance by governments and law enforcement. Then, a court ruling in India confirms that the government can outlaw the use of transport layer security, TLS, a norm developed by the multi-stakeholder community at IETF, Internet Engineering Task Force, to allow client-server communications in a way that prevents eavesdropping. This ruling immediately results in curtailed internet traffic to and from the booming economic region of South Asia. In response, internet service providers abandoned TLS for all of their global communications, raising fears about free expression and civil liberties. Take it away, Suzanne.
Sure, thank you. I had to sort of think about this a little bit, and a couple thoughts come to mind in the scenario about the views and responsibilities of technologists and other stakeholders. It is, in fact, above my philosophical pay grade to resolve the kind of conflict being set up here, but I think I can inform a little bit about what the right questions are and how we might proceed to better understanding. One of the technology pieces, I had to pick a couple, and one is sort of proactive and the other maybe a little bit more reactive. But thinking about what I wish courts understood more widely about how the internet works, even though a lot of what courts have to do isn't related to the technology as such. You know, they can assume the technology. But at the same time, we have structures in place for both the basic architecture of how the thing we call the internet works, and for the stakeholders in the technical infrastructure to evolve standards and norms where that's beneficial. You know, we can evolve the technology just as the uses of it evolve. There are mechanisms for that, and in some ways, that is the most important contribution that the technical community has made. The architecture we have has been developed over time by a variety of stakeholders, and we'll get better regulation and better law enforcement out of understanding some of the basic assumptions we've developed over that process. So one principle I'd like to see the tech community more proactive about explaining is the notion of layers or stacking of network functionality. And this has been alluded to a little bit earlier, so I kind of want to run with it a little bit. Layers or stacking of network functionality is just a set of assumptions about how to separate the functions that are necessary to build a network or application. Easy example, the Netflix app looks pretty much the same no matter where you are and no matter what you're watching and no matter what device you're using. A lot of intermediaries have to do a bunch of different things to make that happen, but one of the reasons why it works is that certain services, the ones required for basic connectivity, the services that applications use, are developed and operated separately to the specific applications. Attacking or limiting those basic services has a much bigger impact on the network than limiting a single app or type of device. There was a reference, I guess Emma made, to collateral damage, and that's where it comes in, is if you're messing with the basic, if you're messing with the infrastructure, not just particular content or applications. What we can do about that, perhaps as a community, we might be able to work towards establishing a norm based on the least necessary force or the least necessary harm to connectivity, which means making it much easier for courts and other stakeholders to distinguish between infrastructure level technology and what we consider application level technology, such as a specific app or database. Blocking access to content is harmful, but blocking a specific app, even Signal, is better than blocking the infrastructure used by that app and many others, such as DNS. So as practical guidance to courts, blocking routing, for instance, or a barrow protocol like TLS is inherently more harmful to basic connectivity than blocking a specific application. And to the extent that the basic value of the internet is in connectivity for whatever people want to use it for, that's a harm worth considering. That's a pretty straightforward equation. As another example, the who is versus GDPR issues are basically not technical. But if you go back to the original who is, the only way to deploy it is with all of the information being public all of the time. Now the multi-stakeholder technical community has built technology that can support a wider variety of policies, including tiered access or open access if that's what you want to do within your local policy and legal framework. This does seem likely to improve the situation overall, no matter what your policy preference actually is. When courts are willing to take a broader-based strategy, though. There's a second principle that can come into play. And again, it's challenging beyond what we'll be able to do today to resolve the jurisdictional issues in any kind of general way. But it's important to remember that the internet really is a network of networks. And separation of control is part of how it functions. The existence and usefulness of the internet depends on the voluntary cooperation of many participants in different networks who all choose their terms to exchange traffic. A given authority can, of course, compel or forbid interactions of a particular type within their own span of control. But the unintended consequence of overextending authority is that others simply won't talk to you. As a colleague of mine puts it, you can only build the internet with carrots. Sticks don't work. If constraints you want to put on people's ability to connect are too difficult, they simply won't. And there's no central coordination point where such decisions can be made on their behalf by someone else. So in the particular scenario, carriers worldwide wouldn't stop using TLS, nor would enterprises within their own networks. People whose governments chose for them not to use it wouldn't have it, but there's no practical way to keep the rest of us from using it. Many other social and economic structures also work this way. You know, many technologists and folks who look at technology think we're inventing whole classes of new problems. Mostly we're not. So many other social and economic structures also work this way. And one thing we know about them is that forcing centralization or uniformity on them often works out kind of badly. So it's better to keep a light touch for that reason also. Finally, I do want to say there's always a tussle going on among these factors, and always a struggle to synthesize. We'll never resolve them perfectly or finally. Technology can't do that any more than any other structure can. And when it comes to the process, tech is only one subset of the stakeholders. To me, a primary goal of the technology is to preserve and extend the ability to have the conversation. And for that reason alone, we need multi-stakeholder mechanisms to make sure the technology is flexible enough to accommodate the full range of the conversation, even though we are not always going to like what other people do with their networks.
Thank you. So now we have an opportunity for some general panel discussion on the relationship between multi-stakeholder processes and outputs and judicial decisions. I guess one thing I would like to do to kick it off is to sort of take an inventory of what the multi-stakeholder processes have been so far. I mean, IETF has had a multi-stakeholder process, and I think generating internet standards. ICANN has had a multi-stakeholder process in generating rules for names and numbering and the like. What other, and IGF itself is a multi-stakeholder process that leads to outputs that are not normative the way IETF and ICANN have been. What other multi-stakeholder activities are really happening, and then what opportunities or rationales are there for further multi-stakeholder processes to assist in this field? Anyone?
Bueller? So I think the absence of response here indicates that multi-stakeholderism is super difficult, right? The typical way that we have kind of international or transnational norms is through governments. So it's not multi-stakeholder, but state-to-state agreements. So trade agreements, Burju and I work on international trade, which is very much non-multi-stakeholder, and the other kinds of norms that are set through international agreements. We've talked about the Budapest Convention and the Hague Convention. Those are the ways that typically international issues have been resolved. Multi-stakeholderism is a much more difficult process. Now, Berkman Center has done a really an incredible job. Urs Gasser and colleagues have done a really nice job of collecting up various examples of multi-stakeholderism across the world, but it hasn't produced the kind of normative impact that ICANN or IETF have as yet.
I want to ask, let me get to you in just a second. I wanted to ask Bertrand because Bertrand, that was meant to be a little bit of a handoff to you, because I think you have a multi-stakeholder process going in the Internet and Jurisdiction project. Let me ask you what hopes you might see for effects of your project upon courts and other things you may want to comment on.
Well, actually, I was about to raise my hand. Thanks, Andrew. One thing that I want to reiterate is maybe the distinction I was making at the very beginning between governance of the internet and governance on the internet. The multi-stakeholder approach has worked really well on everything that is related to the governance of the internet. The technical standards, the distribution of IP addresses, the management of domain names, the DNS in general. I think the whatever people may think of ICANN, for better or worse, this whole set and ecosystem of governance and multi-stakeholder governance mechanism, IETF, World Wide Web Consortium, the IIRs, and ICANN, has basically allowed this, this infrastructure to grow to the billions of users it has today, with honestly an enormous amount of people around the world who have absolutely no idea of how that worked, and it's a testimony to their quality. However, on the other side, regarding the governance on the internet and the usage, which is the second part of the famous definition of internet governance in the World Summit on the Information Society, the system was qualified by Laura Denardis as being inchoate, i.e. completely embryonic. We have the IGF, but it doesn't produce recommendations. It is a great watering hole for people to explain what they're doing. But the key question is that there is an effort in international organizations to involve more actors, but they remain, as Anupam said, fundamentally intergovernmental organizations. And the effort that we're doing is to bring together the different stakeholders on an equal footing around very concrete and precise issues, like the ones I mentioned before: access to digital evidence, content restrictions, and suspension of domain names, in order to develop what we have labeled as policy standards, by analogy with the technical standards. So the goal is to identify areas where there is a modicum of convergence, the possibility of what we can label as mutual affirmation of commitments, where the different actors, the states, the internet platforms, the civil society actors, the IGOs and others, have the possibility to say, if, for instance, requests for taking down of content or access to data are formatted in a certain way according to a certain due process standard, then the companies will be responding in the following manner, and the monitoring will be made by civil society entities or newly created agencies for that matter. The result of the process we're facilitating remains voluntary in the end, but the goal, like technical standard, is that if it solves a problem, if it improves the solution, or if it provides a solution that improves the situation, then the different actors will, in a coordinated manner, implement them. This has been going on for a few years, and we are in the course of we just launched the 3 contact groups that are dealing with this. Some of the people here are fully aware and participating in this exercise, and we will keep people informed of how the discussions evolve. And we have the 3rd global conference of the network in Berlin on the 3rd and 5th of June 2019, in partnership with the government of Germany, and we hope to see those groups produce proposals for operational solutions on very concrete issues by then. On the impact of courts, it's more about contributing to the awareness and the education, I think.
Thank you, Bertrand. We're going to have Emma, then Ali, then Suzanne. If we take 10 minutes for a total of that, we'll have a few minutes for questions from the audience at the end. Take it away.
And I'll try to be brief, but I wanted to kind of echo what Anupam was saying of the kind of the formal, totally independent multi-stakeholder structures there's not a giant list of those, but there is a lot of work to involve multi-stakeholder perspectives in some of the more traditional kind of government-led or bilateral or multilateral decision-making bodies, whether that's governments making sure that their delegations to the ITU are actually open to a variety of stakeholders from their country, or here in the U.S. we have the NTIA running multi-stakeholder processes to try to talk through difficult issues, doing notice and comment rulemaking, right, in our different administrative agencies is a key way that the U.S. has used for a long time to get input from lots of relevant stakeholders. And I think it's important for us to keep that in mind as part of the multi-stakeholder model, that as we're in this inchoate, kind of transitional maybe phase from government-led to truly multi-stakeholder from the ground up bodies, there's still plenty of opportunity for bringing in the expertise of the variety of stakeholders out there, including in courts. And so, I think one of CDT's big priorities since its very beginning has been bringing technical perspective into court cases through amicus briefs or interventions globally. And that's been really key, as Suzanne is talking about, there's a lot about that, as you were talking about kind of the principle of least necessary harm, right? Sounds like least restrictive means analysis in First Amendment law, or proportionality analysis globally. There's ways that courts think about the effect of their decisions that would be and are incredibly informed by understanding the technical realities and technical underpinnings of the systems that they're adjudicating. I'll just echo Suzanne's call for more involvement of folks with technical background and expertise in roles like amici and interveners in cases, because that is the easiest and most direct way to inform courts about these issues.
Thank you. Ali.
Emma's kind of stated this, but I feel like we can't talk about multi-stakeholder without shouting out NTIA again. They just took comments on international internet policy priorities, where there was a whole section on these jurisdictional challenges of free flow of information and extraterritorial applications of law that CCIA and I'm sure a number of other groups participated in. So there are definitely these processes, as Emma described in more detail. And while I have the mic, I didn't get a chance to respond to Andrew's first question. I wanted to say that there are a variety of impacts on companies of different types of court decisions and types of law. The example I was going to mention before we moved on, but is that it really impacts companies of all types of sizes and all types of resources. And for example, a few years ago, Spain and a few other European countries have been passing laws on ancillary copyright and snippet taxes. And after that law passed, Google News shut down in Spain. So these really can have impacts on both of court decisions and other types of policymakers from legislatures. Really can have impact on firms operating globally of all types of resources. Back to multi-stakeholder.
Thank you, Ali. Suzanne.
Just sort of a quick comment on the role of standards and all of this, and the role of the IETF. There's what the IETF does is voluntary standards, within the framework of how standards bodies work and so on. And there's actually an aphorism that's so common that it's a joke that we have to keep telling each other. I co-chair the working group of the IETF that publishes documents on the DNS, the protocol extensions to the DNS. And we do have to remind ourselves on a regular basis that there are no protocol police. What we're doing is strictly voluntary, and it's a classic multi-stakeholder process in the sense that what we need is in order for something to become part of the standard, we end up having to make sure that interests and incentives are aligned to the level of consensus across the set of people that have to buy in and say, yes, I will do this, I will implement this in my network. And I think that's what makes that's a good example, that's a picture of what makes multi-stakeholder hard and why it takes years.
So I'd like to open up for questions from the audience. I prefer questions, please, to comments. If we don't have questions, we can move to comments. But I see a question over there.
If I could offer a back to the future question, it is that about 20 years ago, a group of
Oh, can you introduce yourself, please?
Sure. My name is Roger Cochetti. I work with private equity in the technology sector and have been involved in internet law and policy issues for a long time. And about 20 years ago, a group of companies who were at that time the giants of the internet industry came together to address exactly the same issue. And in a series of international conferences that took place in Montreal and Washington and San Francisco and Tokyo, addressed almost the same subject repeatedly. Now, to set your Wayback Machine, in 1998, the internet giants were Netcom, NetSol, Schlumberger, British Telecom, Nippon Telecom, Fujitsu, and Jeff Bezos had just quit his job as an investment banker to form a new company. Sergey Brin and Larry Page were grad students, and Mark Zuckerberg just graduated from junior high school. So it was a different world, but the issues were not vastly different. And over a period of several years, most of us involved in the exercise understood that at some point in the future, the internet would have 500 million people using it, and that countries as opposed to the internet as France and Russia and China would have large numbers of people involved in the internet. So we understood that the issue is looming in the future, and over a period of years came to the consensus that there were probably 3 outcomes that would take place, and I'd like the panel to react as to which of the 3, if any, are the ones that took place. There was the utopian view that at some point there would be 20 or more countries using the internet, and they would form a treaty, and the treaty would set the rules for international cooperation, much as had been the case with piracy in the high seas and outer space and postal and telegraph and other things. There was the dystopian view, which is that nothing is going to happen. There will be mass cross-border crime, mass cross-border, we didn't use the words terrorism, but bad activity taking place, and the bad guys would always be 2 steps ahead of the good guys because there was no way to find them or do anything about them. And then there was the pragmatic view, which was that, well, this is all going to work out through a series of arbitration, where companies will, Nippon Telephone and British Telecom and Schlumberger will establish a consortium when they'll do arbitration among them to resolve jurisdictional disputes. And I'm not sure that any of those scenarios worked out, maybe the dystopian one, but if you could go back to 1998 and tell the people involved in that effort what was the future going to provide, what would you tell them?
Any thoughts here from the panel? I'll just throw out one straw man answer, which is that a variant of the utopian view existed until about 6 years ago, but it wasn't a treaty. It was American pervasive dominance of the internet without the need for a treaty, because we have been speaking in terms of harmonization, but most Americans are saying, yes, we must harmonize our way of doing things. And that doesn't hold any longer, and particularly in the last 4 years, that has completely fallen apart. And I guess, I don't know if others agree with me, but the question is, what is about to replace that? Any thoughts? Anupam.
So another thing I might add to the 1998 vision was the idea that cyberspace was a place. It was like outer space, and so we could think of this as a regulation of outer space. It turns out cyberspace is inside us. It's everywhere. It is us. It's the way we live. It's everything. And so it's to regulate cyberspace is to regulate ourselves, our bodies, our relationships, our interactions, our how we got here, how we go home, how we eat, how we date, and everything. So in other words, there wasn't you can't come up with a body of 20 states that creates rules for cyberspace because that's creating rules for everything that we do.
That's a great observation. Emma?
And I think we're obviously clearly past the point where there's only 20 countries online, right? And so that immediately makes the concept of doing a global treaty today a much more fraught question, because it would, appropriately for a global treaty on any issue today, need to involve all of the countries of the world, and that's a much bigger divergence of opinion about the right way to approach things than we might have imagined in '98, looking at, say, US and Western Europe countries being the likely, early adopters who have a more of a common set of interests and approach to human rights issues and crime. But there have also been, I think short of reaching an international treaty, there certainly has been a lot of effort among different governments around the world to coordinate on issues like cybercrime, and one of the big questions that I know that Bertrand, among others, has thought a lot about is, cross-border access to data held by a company, headquartered in the US with servers around the world. When and how and under what conditions does, a German official investigating a crime between Germans in Germany, are they able to compel a US-based service provider to hand over information? So, I think some of the thing that keeps us from a full dystopian view, right, where crime is rampant and there's absolutely nothing to do is, international law enforcement and international intelligence has become and had incentives to coordinate amongst themselves, even if below a level of treaty, notwithstanding the Cybercrime Convention.
That was such a good question. We're going to close with it by doing a run of the panel of 1 minute of each of the remaining speakers. So we'll go from my right with Stephen to my left.
Yeah, so I would like to tell them it's a utopia. I'm an internet true believer. I think there are lots of utopian corners of the internet, and I try and spend my time there. But I think that really, you can boil this down to like an unplanned internet or a planned internet. One that is pragmatic or one that's driven ad hoc by court decisions and anecdotes and news headlines and regulation that strikes back. And I think we've ended up with that less planned, the less pragmatic, anecdote-driven internet. So if I had a time machine, I would tell people that this is going to be driven by anecdotes. Be very careful which anecdotes you tell.
Thank you. Suzanne.
I think my flippant answer to the question would be all of them. Mod the fact that there's no formal treaty among those 20. But there's 20 countries that are probably more important in terms of their economic and social throw weight on the internet than the rest, and the rest want their part too, and that's perfectly appropriate and understandable. But it does remind me a little bit of there's a quote attributed, I think, to Neil Stephenson. The future is already here, it's just not evenly distributed. And I would add that it never will be, and that anecdotes are a big part of what happens, but also we've managed to solve or at least improve the situation around some of those problems we were worried about in 1998. And we'll continue to screw it up in some ways and continue to get it right in others.
Thank you. Allie.
And I would respond to two other parts of the question. One was just the list of companies that were mentioned, just showing how much industry and changes, even just over 2 decades, and some of it might be because of different changes in law and policy and court decisions. Some of it is just changes in the industry and then the markets and the business. But I think that's a relevant consideration to making policy. It's not always just about the stakeholders are there right now. You have to think about the future and also be cognizant of the past. And the second would be that in the late another thing that was happening around that time is the two really important U.S. intermediary protections were passed in the late 90s, the DMCA and Section 230, and those are things that are still around and still remain really, really important to industry and to the folks that want to speak online. So, yeah.
Last but not least, Bertrand, please give us some final parting words of wisdom.
Sorry, and I realized I was not muted, so I didn't cough just to remind you that I was there, but thanks for thinking of me. No, just say one word regarding the question that was asked. There's a need for innovation governance mechanisms. We are not and we shouldn't be caught between a binary choice between full reterritorialization of the internet and the utopian John Perry Barlow completely self-organized and hors sol, off-the-ground type of cyberspace. What is at stake, I think, and that's purely personal, I do not commit the participants in the INJ policy network in there, but I would make an analogy with the internet and the web. the internet was built by connecting heterogeneous networks through a simple protocol. The World Wide Web was connecting information systems through a simple protocol. What we have today is heterogeneous governance frameworks, the courts, the countries, the companies, civil society groups, any kind of subgroups, and Wikimedia being one that is a norm-setting entity as well. And what is at stake is how do we make this set of heterogeneous governance groups and frameworks work in an interoperable manner, respecting their identity and making sure that they can coexist in a cross-border space. And this is a big challenge, and it requires that people have an open mind on what are the innovative things that can be done on an issue-by-issue basis. Not an overarching treaty for the whole of the internet, but a case-by-case basis, getting the right stakeholders around the table and making them work on that.
Thank you, Bertrand. And I'll ask the audience please to join me in thanking this panel of remarkable thinkers and speakers. Thank you. And now there is caffeine.